Hello and good day to everyone. We are privileged to have some important individuals among our speakers today. Welcome, Bapak. So we'll be talking about climate justice today, or this evening. One of the main causes of climate crisis is land and forest fires, and especially in peatland ecosystem. So besides mitigation and adaptation efforts, and then the national regulatory and policy, and then the other energy transition initiatives, litigation approach become one of the key instruments in restoring the environment and all the other efforts. So before we go and delve into the discussion today, allow us to invite the legal advisor Inc. from UNFCCC, Mariana Bolsakova, to set the tone for all of us. Thank you.
Good afternoon, and it's really a pleasure to be here, and I will very much try to overshout whatever's happening next door. So it is a very much pleasure to be here on behalf of the Legal Affairs Department of the UNFCCC, and to join you in this extremely important and very, very timely discussion. I would like very much to extend our thanks to the Ministry of Environment of the Republic of Indonesia for the invitation, and to also commend Indonesia for planning to bringing this global attention to a topic that lies at the heart of climate justice, the role of law enforcement and the role of the judiciary. I welcome the opportunity to reflect together, all of you, on how the environmental law enforcement, litigation and governance are increasingly central to advancing climate justice. Climate change, humanity's greatest challenge, is not only a scientific issue, it is fundamentally a question of justice. The IPCC's sixth assessment report that was released last year reminds us that limiting global warming to 1.5 degrees Celsius still remains possible, but only if our collective commitments of all of us together, all of our countries together, are translated in something that is measurable and an enforceable action. Achieving climate justice means ensuring that burdens and benefits of climate action are shared fairly, and that those that cause environmental harm are held accountable. Laws and policies matter, but without effective enforcement of those laws and policies, enforcement that goes through investigation, enforcement through prosecution, and enforcement through judicial redress, even the most strong legislation that you may develop remains only aspirational. So it needs that enforcement and judicial action to be real. In this context, Indonesia's experience is very highly relevant, and over the last decades, the country has shown that consistent law enforcement can directly contribute to emission reduction and ecosystem recovery. The decline in forest and land fires, especially in peat ecosystems, demonstrates how preventive governance, restoration, and litigation taken together can advance climate goals and protect vulnerable communities. These are not only national achievements, they represent an emerging global model where environmental law enforcement becomes a pillar of climate justice, linking corrective measures such as restoration and redress with procedural justice, including access to information, participation, and protection of environmental defenders. Across the world, environmental enforcement and climate litigation are now converging as powerful tools for accountability. And let me highlight some of the global data and trends on climate litigation. And to look at more details on this, I invite you to look at the UNEP's, the UN Environment Programme's 2025 Global Climate Justice report, and it was published very recently in June, so the data is very, very fresh. But I'll just highlight a couple of things from the report. As on June this year, the end of June this year, there were 3,099 climate change litigation cases filed globally. These span 55 jurisdictions and 24 international regional courts, tribunals, and other adjudication bodies. While most of these cases remain concentrated in a few countries, so 55, the trend is expanding, and it is expanding very rapidly, and especially in the global south. Increasing number of lawsuits address land use and pollution and forest protection. Many of these cases draw very much directly on environmental enforcement mechanisms, linking traditional environmental damage claims to broader climate impacts. Importantly, and as this UNEP report notes, litigation today does much more than just seek remedy. It helps legislation and it helps policies. It frames human rights obligations and redress climate harms. This report highlights that effective enforcement and judicial oversight can lead to reduced emissions, it can promote restoration, it can help protect human rights, and ultimately, these law cases, they strengthen credibility of climate commitments. There are also several recent advisory opinions that I wanted to highlight for your attention, and these mark very important milestones in the legal architecture that underpins environmental enforcement. In May 2024, the International Tribunal for the Law of the Sea delivered a landmark advisory opinion, and that opinion was delivered in response to a 2022 request from the Commission of Small Island States on Climate Change and International Law. This advisory opinion from ITLOS, it affirmed that GHG emissions absorbed by ocean constitute pollution under international law, and that therefore states have an obligation to take all necessary measures to prevent and control such pollution. And then more recently, and many of you will be very familiar with this, just this year, the International Court of Justice, the ICJ, issued an advisory opinion on the obligation of states in respect of climate change. And that was done in response to a request made in 2023 by the General Assembly of the United Nations. This very much groundbreaking advisory opinion found that states have binding obligations under international law, so it establishes that it has binding obligations under international law to prevent and reduce GHG emissions and to protect climate system and other parts of environment from anthropogenic harm. According to the court, according to the ICJ, these obligations derive not only from UNFCCC and its Paris Agreement, but also from customary international law, including duty of prevention and the obligation of due diligence that all states have. While the advisory opinions are not legally binding, and we do know they're not legally binding, this one carries a very, very significant legal, moral, and political weight coming from the ICJ. It reinforces the view that climate inaction has legal consequences, and that protecting the climate system is a shared and enforceable obligation owed to present generation, to ourselves, and to our future generations. But it is not only international tribunals that consider climate obligations. And I want to mention a landmark ruling that came from Asia Pacific, and that is from August 2024, where the Constitutional Court of the Republic of Korea ruled that parts of the country's Carbon Neutrality Act were unconstitutional. And that was because they failed to set a post-2030 reduction targets. So the court held that this omission violated the constitutional rights of future generations under the Constitution of the Republic of Korea. And the court ordered the law to be revised to include the targets up to 2050 that are based on science, they are based on international standards, and Korea's fair share of global effort. This was the first time that climate change was recognized as a constitutional rights issue within the Republic of Korea, and it set also an important regional precedent, reinforcing the role of courts in holding governments accountable for climate action. These legal developments, they complement the work that we do here in this venue and in the UNFCCC process overall. Litigation, when it is grounded in solid enforcement and governance, can reinforce and accelerate the implementation of the Paris Agreement. Through the judicial interpretation, the courts help clarify what states, as well as non-state actors, must do to meet national targets and long-term strategies. Judicial scrutiny and it enhances accountability, and it can serve as a compliance accelerator when political and administrative processes fall short of our expectations. At the same time, court decisions can catalyze ambition. Judicial scrutiny often prompts governments and corporations to strengthen their policies, to update their targets, and to align actions with the 1.5 goal. And crucially, litigation bridges the global and domestic levels, and it translates the international commitments that we make in the COP and other bodies into something that is concrete and something that is enforceable at national level through national obligations and actions. Far from standing outside of the UNFCCC process, these developments show that enforcement and litigation now form part of the systemic effort to implement the Convention and the Paris Agreement. Within the UNFCCC framework that is our home here, enforcement is not peripheral, it is fundamental. Law enforcement ensures that national targets are respected, it deters environmental harm, and it turns commitments into measurable outcomes. It also strengthens transparency and trust. So enforcement is not the end of the climate effort, it is what sustains its credibility and its fairness. Of course, challenges remain, and many countries face limited capacity and resources to enforce environmental laws. Even when cases and law cases, court cases succeed, delays in implementation can weaken results. And sometimes, and we all know in climate and environmental law in general, proving causation also remains quite complex. Yet, these challenges also open opportunities to deepen international cooperation, and you hear a lot about international cooperation at this COP. They offer opportunities to exchange knowledge and experience and to build networks among the enforcement officials, agencies, prosecutors, judges, and policymakers. So we at the UNFCCC continue to support parties in building their legal and institutional capacities. And our division, the Legal Affairs, provides training and technical assistance on procedural issues, on how compliance mechanisms work, and also on negotiation processes. Last year, we worked very closely with Indonesian negotiators to explore how domestic legal systems can support climate implementation and can respond effectively to emerging legal challenges. These efforts aim to use the rule of law not only for enforcement, but as a bridge that connects international commitments to national practice and links national enforcement to global justice. We also contribute to broader capacity building efforts in the Asia-Pacific region. I'm very pleased to say that. And for example, last year we've participated and contributed to a course on multilateral environmental agreements that was organized in Bangkok together with UNEP and University of Eastern Finland. And these kind of efforts, they bring together government officials, they bring together negotiators, NGOs, private sector, and academia. And the collaboration among all these stakeholders is vital for equipping both current and future generations with the knowledge and skills needed to strengthen treaty implementation. So, ladies and gentlemen, the message emerging from both global jurisprudence as well as the leadership of countries like Indonesia is very clear. Climate justice is indispensable from law, and it is also inseparable from law enforcement. Law enforcement and litigation make climate commitments credible, equitable, and fair. They turn justice from a principle into practice. And we look ahead to continue to strengthen this cooperation that we already have ongoing, to share lessons and experiences, and to build legal and institutional capacities needed to turn justice into climate action and to turn climate action into justice. So thank you very much, and I look forward to the discussion. Thank you.
Thank you. Mariana, please have a seat. Don't forget you're one of our panel today. Thank you. Okay, so International Committee has mentioned that government holds accountable and have legal consequences for the climate action. So we need to align our perspectives today. Our panel will enlighten us on what are the key challenges in implementing the or enforcing the law to protect the environment. They also will share their experiences handling any cases that probably come to their table, which can be perhaps replicated and scaled across the region. And they will also demonstrate Indonesia's commitment in climate diplomacy for environmental law enforcement and restoration process. So I would like to call upon all the speakers. Being the first one, he is the Chief of Deputy for Environmental Law Enforcement from the Ministry of Environment Indonesia. Please welcome Bapak Irjen Pol Rizal Irawan. Following, he is the Chief of Chamber for Criminal Cases. Pak Jenderal, please have a seat. It's going to be more comfortable for you, I promise, than standing up the whole time. Thank you. My third speaker, he's the Chief of Chamber for Criminal Cases, Supreme Court of Indonesia, Dr. Prim Haryadi. Since it's law enforcement talk, we're going to have some serious discussion. We have the Head of Environmental Governance and Pollution Control, Mbak Marsha Handayani.
Okay, good afternoon, ladies and gentlemen. But before we start the discussion, I would like to invite Bapak Deputy, Pak Irjen Pol Rizal Irawan, to give a token of appreciation to Ms. Mariana Balsakova as she have another meeting. So, and we can take pictures together before Mariana leaves. And I will invite the fourth speaker, Krista Shannon from Climate Rights International. Please welcome. And we will have a photo together before we start, before Mariana. Satu aja. And thank you so much, Mariana, for making time here. And I think we can take photos together for Mariana leaving. Other panels too, with Justice Prim and Krista. Please give applause to Mariana and don't worry. Thank you very much. So, thank you, Miss MC, for introducing us. So today panel will gather to reflect on how Indonesia's experience in environmental law enforcement can help advance the climate justice, strengthening accountability, and support global efforts to stay on track with the 1.5-degree goal. Climate justice goes beyond reducing emissions. It is about ensuring that communities, especially the vulnerable, are protected, and that ecosystems are preserved, and that legal and institutional frameworks respond to effectively to environmental harms. Indonesia's experiences from enforcement in the field to decision making in the courts show how law can serve as a powerful tool in climate action. To explore this, we are honored to have four distinguished speakers who will share their expertise from government, the judiciary, and the previous one, international legal institution, and the civil society. So our first speaker is Inspector General of Police Rizal Irawan, Bapak Rizal. As the Deputy for Environmental Law Enforcement, Ministry of Environment, he will discuss the Ministry of Environment's role in protecting the climate through environmental law enforcement, Indonesia's climate commitments, and how enforcement supports them, and key achievements in environmental law enforcement, including action against pollution, forest fire, and environmental degradation. His speech will provide an overview of Indonesian institutional efforts and how enforcement contributes to a more climate resilient future. Please welcome Pak Rizal.
Assalamualaikum bro. Tes. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, Your Excellencies, distinguished delegates, esteemed scholars, colleagues. Justice Prim Haryadi is a Chamber of President for Criminal Cases, Supreme Court, Indonesia. Mariana Balsakova, and then Krista Shenum is a researcher from Private Rights International, and Marcia from ISL. Ladies and gentlemen, whom I honor. I deeply honored to be here today at the Indonesian Pavilion of COP30, and our session is to achieving climate justice through environmental law enforcement, lesson learned from Indonesia. Thank you for joining us for this important discussion. First of and foremost, let us express our gratitude to God Almighty, for it is His grace that we are able to gather here today to this meaningful event. Forum holds great significance as it provides as important space to continue strength dialogue on environmental law enforcement in Indonesia. For us, it serves a strategic platform to reflect upon the improve for environmental legal frameworks and practices. For the international community, we are hope this discussion will offer valuable insight into Indonesian experience, showing how environmental law enforcement can be a pathway toward achieving ecological justice. Excellencies, ladies and gentlemen, Indonesia remains strongly committed to achieving ecological justice. As a party of a Paris Agreement, we are actively working to contribute to the global goals of limiting the increase of the average global temperatures to well below 2 degrees Celsius above pre-industrial levels, while pursuing effort to limit the temperature rise to 1.5 degrees Celsius. The commitment was reaffirmed by our President, President Prabowo, in his address at the United Nations General Assembly, where he reiterated that Indonesia's determination to uphold the Paris Agreement to achieve net zero emission by 2060 or earlier. Indonesia climate target aims to reach net zero emission with a greenhouse gas reduction goals of 31.89% through domestic efforts and 43.20% with international support by 2030. By commitment, in further reflected in Indonesia's ambition to increase the share of renewable energy to 23% of the national energy mix by 2030, demonstrating our resolve to accelerate a just and inclusive low-carbon transition. Ladies and gentlemen, to achieve the environmental target, Indonesia places environmental law enforcement as one of its main pillars. The country recognizes several established forms of legal standing, including individual legal standing, class action, government legal standing, citizen lawsuit, and environmental organization right to sue. For instance, citizen lawsuit allow any Indonesian citizen to bring a claim against the government, state institution, or private entities for negligence to failure to fulfill their legal obligation that harm public interest, such as 2019 in Jakarta air pollution case filed by Melanie Subono. Environmental organizations also have the right to sue to preserve environmental function, limited to demanding a corrective action without compensation claims, except for actual expenses such as laboratory and court fees. In the case of class action, communities can collectively file lawsuit when they suffer losses due to environmental pollution or degradation. According to Article 19 of the Environmental Protection and Management Act, EPMA, government institutions and regional government responsible for environmental affairs are authorized to file lawsuit for a compensation and or specific action against business or activities that cause environmental pollution and or degradation resulting in environmental damage. This authority is further affirmed in Presidential Regulation number 182 of 2024 on the Ministry of Environmental, which state that one of the ministry's core function is the enforcement of environmental law. Furthermore, under the regulation of the Minister of Environment of the Republic of Indonesia number 4 of 2013 concerning guidelines for environmental dispute settlement, which is currently under revision, the minister, governor, or region manager shall have the duty of authority to carry out the settlement of environmental disputes, with the minister having an option to delegate this authority to the official responsible for environmental law enforcement. In this regard, the Government Act not parents patriae, but as a trustee of natural resources for the benefit of the public. The key foundation of Indonesia environmental law enforcement is the strict liability rule, which impose legal responsibility on perpetrators without requiring proof of fault. Under this principle, plaintiffs only need to demonstrate the act, the damage, and the causal link. This has significant strength to government ability to propose legal action, as it removes the burden of proving intent or negligence. On prominent case in that of PT Jatim Jayaperkasa, where the MOEF successfully sued the company for recurring peatland fires in its palm oil concession. Supported by scientific evidence and community reports, the court granted part of the government claim, including material compensation and restoration orders. This case illustrates how the strict liability principle reinforce Indonesia environmental enforcement framework, enabling the government to act decisively without the need to prove fault. Ladies and gentlemen, achieving our ambition target requires more than just policy. It requires robust governance and steadfast commitment to the rule of law. Our ministry and environmental enforcement unit is the operational arm in this commitment. Let me provide a clear, recent example of the principle in action. We are currently addressing a significant air quality challenge in our capital region, a home to over 34 million people. Our response is not a single action, but a coordinated effort targeting all identified emission sources. While this form of mitigation may not directly relate to climate change, it demonstrates how environmental governance can deliver immediate benefit for public health and long-term sustainability. First, we are holding our industrial sector to a higher standard. Our enforcement body is systematically inspecting 48 industrial zones across the region. It's not about monitoring. Under the minister's direct leadership, we have already initiated legal proceeding against 13 non-compliant industry facilities, from metal smelters to textile factories. Furthermore, we are mandating the major industries install continuous emission monitoring system or SEMS and modern pollution control devices, ensuring real-time accountability. Second, we are addressing the largest contributor, transportation. We are working with our national energy companies to accelerate the availability to a low sulfur fuel equivalent to Euro 4 standards. Simultaneously, we are collaborating with transportation authorities and national police to implement mandatory vehicle emission tests with financial penalties, targeting the highest polluting vehicle first. And the third, our enforcement is extended to the perceived issue of importer waste management, which is a challenge to require action to both of scale and the local level. We have issued formal governor coercion order to 343 non-compliant landfill across the country to enforce operating standard. At the same time, our teams are on the ground shutting down local illegal dump sites in major cities. This example illustrate that our approach in comprehensive, this is not an arbitrary action. It is an execution of our legal mandate as a second layer law enforcement body. Whatever, whether in a factory, a vehicle on the road, a waste facility, our message is consistent. Indonesia is serious about enforcing its environmental laws to protect the health of our people and the integrity of our climate commitment. Furthermore, in just the first half of 2025, the Directorate for Environmental Dispute Settlement, or PSLH, has handled 74 environmental cases, both through litigation and non-litigation channels. The outcomes have generated non-tax state revenue amounting to about in Indonesian rupiah and about 170 to 28 billion, delivered from compensation and environmental restoration by business actors. But it's not merely about numbers, as it reflects accountability and paradigms shift. These funds are being allocated to strengthen the support of environmental restoration. This milestone affirms that the government of Indonesia is fulfilling its obligation in accordance with the advisory opinion in the International Court of Justice on the obligation of states in respect of climate change, which underscores the duty of a state to achieve the temporary goals of limiting global warming to 1.5 Celsius above pre-industrial level as stated in Paris Agreement. As we move forward, Indonesia's vision is clear, strong environmental governance and law enforcement are the foundation of sustainable growth. We are turning environmental protection from a moral aspiration into a measurable national performance. We recognize that achieving climate justice is not a task to one nation alone. It requires collective will and strong and multitarism. Indonesia stands ready to work hand in hand with other nations in ensuring the safeguarding our planet to future generations. On behalf of the Ministry of Environment Indonesia, I would like to express my deepest appreciation of law enforcement institution in Indonesia who have been working hand in hand with us, our core organizer, the Indonesian Center for Environmental Law, and to all distinguished speakers and participants here today. May this seminar serve as a reminder to our shared responsibility and a catalyst for greater cooperation in the pursuit of climate justice. Because in the end, enforcing law is not merely about compliance. It's about safeguarding life itself. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Pak Rizal, for your insightful presentation and for highlighting the crucial role of enforcement in meeting Indonesia's environmental and climate goals. It is truly an amazing work that you've done. More than 100 cases within 2025 and reach 200 for something US dollar for restoration. So moving forward, our third speaker, we have Justice Prim Haryadi, Chief of Criminal Chamber Supreme Court of the Republic of Indonesia, will share insight from the Judiciary. His presentation will cover the court's role in advancing climate justice in Indonesia, Supreme Court policy that strengthens environmental law enforcement, the Environmental Judges Certification Program, and Supreme Court regulation designed to support clear and consistent adjudication in environmental and climate-related cases. This reform represents Indonesia's commitment to enhancing judicial capacity in responding to environmental challenges. Justice Haryadi, we welcome your remarks.
Thank you, Marsha. First, I would like to say thank you to Mr. Deputy of Environmental Law Enforcement of Environmental Ministry was invite me, Supreme Court, to join this conference. Okay, good afternoon, distinguished participants, colleagues and friends from around the world. It is great honor for me, on behalf of the Supreme Court of the Republic of Indonesia, to take part in this important global forum, COP30 here in Belém, Brazil. We gather today in the heart of Amazon, a region that breathes for our planet, to reaffirm that climate action is not only about science and policy, but also about justice. Indonesia, much like Brazil, stands at the front line of climate reality. We are an archipelago of over 17,000 islands, home to immense biodiversity, from the coral triangle of Raja Ampat to the tropical rainforests of Kalimantan and Sumatra, and the mangrove ecosystem of Papua. Today, I will share how our courts have turned environmental adjudication into a pillar of climate justice, how verdicts lead to restoration, and how law itself can help the earth. Every year, Indonesia faces forest and land fires. When peat burns, it releases carbon stores for millennia. In 2015, Indonesia daily fire emission exceeded those of the entire US economy. This fire spreads hazard across Southeast Asia, destroying biodiversity, endangering lives and harming regional trust. But they are not natural. They are the result of negligence, weak enforcement, and unsustainable land use. They jeopardize our national determined contribution (NDC) and undermine collective climate efforts. The turning point came when Indonesian courts began to see these fires not as unfortunate events, but as a crime against the environment and the climate. When the law speaks, the forest breathes again. When justice acts, restoration begins. When trees pitch and vegetation burn, carbon stored in biomass is instantly released into the atmosphere. Even after flames fade, decomposing organic matter continues to release greenhouse gases for years. In Indonesia, scientific data is now present in court as part of environmental evidence. Satellite imagery, emission models, and expert testimony have become judicial tools. This integration of science and law transforms and law transform litigation into a bridge between courtroom reasoning and planetary reality. It marks a profound evolution from evidence of guilt to evidence of climate impact. In the past decade, Indonesia has seen the emergence of climate-related litigation. As of 2025, more than 20 cases have been filed in Indonesia. A landmark example is the Tanjung Jati coal power plant case, in which citizens claim that project's emission violates their constitutional right to a healthy environment. This signals to encouraging trends. One, citizens and NGOs are becoming more climate literate, and two, courts are ready to consider climate science since within the framework of justice. Indonesia Judiciary is no longer a passive bystander. It is an active participant in the fight against climate degradation. Ecological impact, loss of biodiversity, drying peatlands, degraded forests, economic impact, agriculture failures, damaged infrastructure, losses of hundreds of billions of rupiah, public health, respiratory disease, and school closed during hazard season. Reputation, our environmental performance influence global trust and investment. From 2015 until now, Indonesia recorded 24 major environmental litigation cases. 12 have been enforced, 10 remain ongoing, 1 is on trial, and 1 reached settlement. The total environmental losses exceeds 671 billion Indonesia rupiah, Indonesia currency, with restitution of 333 billion Indonesia rupiah ordered by courts. Its case has created new legal precedents on a corporate liability, restoration obligation, and the use of scientific evidence. Legal victories now lead to tangible environmental recovery. Verdicts are followed by replanting programs, pitch rehydration, and pollution control. Monitoring terms, including experts, academics, and community representatives, ensure that restoration is not symbolic but real. As a result, vegetation has regrown, air quality indicators have improved, and pit water levels are stabilizing. This shows that law can do more than punish. It can heal. To sustain progress, the Supreme Court issued Regulation Number 1 of 2023, a guidelines for environmental case handling. It introduced 6 key principles. 1. Recognition of climate case as environmental cases. 2. Clarification of liability, including absolute and market share approved. 3. Requirement of recovery plans in every decision. 4. Strengthening of corporate criminal liability. 5. Detailed rules for scientific evidence and expert testimony. And 6. Anti-strategic lawsuit against public participation, protection to safeguard environmental defenders. The purpose is clear: to enable courts to make decisions that realize sustainable development and ensure environmental and climate justice for the people and natural resources of Indonesia. With this regulation, justice becomes a framework for sustainability, not only a verdict, but also a vision. I think that's all. Okay, sorry. Since 2012, Indonesia has certified 1,738 environmental judges. To qualify, a judge must serve for 10 years and demonstrate integrity and expertise in environmental law. The training curriculum includes international principles, climate change science, scientific evidence analysis, and anti-SLAPP proceedings. We train judges not merely to punish, but also to understand an ecosystem, so they can see justice and sustainability as one and the same. Indonesia Judiciary will continue to strengthen foundation of climate justice. Accountability. Polluters must be held responsible. Restoration is not optional. Restoration, every verdict must contribute to ecosystem healing and community resilience. Credibility, our judiciary must reflect science-based decision making and global trust. That is the end of my presentation. Thank you for your attention.
Thank you, Justice Haryadi, for highlighting the judiciary's significant role in safeguarding the environment and ensuring justice for the environment itself. I think that Supreme Court of Indonesia has a great role in fulfilling ecological justice, and it is a progressive landmark as you have an environmental certification judges as well as the regulations to hold the corporation and entities liable to what the harm they cause to the environment. So moving on to the final speaker, there is Ms. Krista Shannon, from a researcher from Climate Rights International, will present a human rights-based approach to climate justice. She will discuss how human rights principles strengthen climate litigation, why community protection and participation are essential, and basically bridges the legal, social, and ethical dimension of climate justice. Ms. Krista, we invite you.
Thank you. Hear me? Thank you, Mariati. First, I'd like to acknowledge the incredible co-panelists here, Deputy Minister and Justice. It's an honor to be sitting with you. My name's Krista Shenham, and I'm a researcher at Climate Rights International. We are an international human rights research and advocacy organization. We focus on the human rights impacts of the climate crisis. So I'll be talking a little bit today about some human rights-based approaches to climate change. And I think first to start, I'd like to acknowledge that there is no way of talking about climate justice or the climate crisis without also talking about human rights. These two things are intricately linked. The climate crisis is fundamentally a human rights crisis. It threatens the rights to life, food, water, housing, culture, the right to a healthy environment, and many more fundamental human rights. Around the world, countries have legal obligations to respect, protect, and fulfill the human rights for all. Now, this includes not only civil and political rights, like the rights to expression and to assembly, which we're seeing pretty live at COP. This also includes economic, cultural, and social rights. The core human rights covenants, including the International Covenant on Civil and Political Rights and the International Covenant on Economic, Cultural, and Social Rights, are law enforcing. They are declaratory in nature, meaning that they create law. This is an obligation. This is not a option. I'd just like to acknowledge that Indonesia is a party to both of these conventions, which is and since 2006 has been a party to the International Covenant on Economic, Cultural, and Social Rights. Briefly on the work of my organization, Climate Rights International, the way that we work is we conduct in-depth, on-the-ground investigations into the impacts of human rights and climate change. Our research illustrates many of the ways that climate change, the drivers of the climate crisis, like burning fossil fuels, as well as some of the solutions to the climate crisis itself, including the energy transition, are not only environmental issues, but they are also human rights issues. For example, the extraction of fuels, fossil fuels like oil and gas, and the burning of coal, including captive coal, which are not only the primary emitters of greenhouse gas emissions that are largely responsible for the climate crisis, are also destroying livelihoods, leading to food insecurity and harming access to education around the world. Deforestation, which releases carbon and helps drive climate change, is also threatening access to food and water. It is threatening land rights, indigenous peoples' rights, and the right to a healthy environment. People on the front lines of the extraction for transition minerals or critical minerals, minerals like nickel, are facing food insecurity, extreme air and water pollution, devastating environmental impacts that are not only destroying their lives, but also their livelihoods, including fishing and farming. My organization, Climate Rights International, has documented specifically the human rights impacts of nickel in both Indonesia and the Philippines. Quickly to touch on what our first speaker spoke about with the International Court of Justice recent advisory opinion. This is not only incredibly important for countries' obligations under the climate crisis, but also the connections with human rights. The ICJ squarely recognized that the climate crisis is a human rights crisis, and it also finds that rights are directly implicated when states fail to act on climate change. It urges and obligates companies and governments to take action to address climate change in order to respect human rights. This obligation to act also includes the obligation to regulate the action of private actors, including businesses, including by adopting and enforcing laws and regulations that require companies to prevent and mitigate climate-related human rights risks. I'd just like to highlight some examples from around the world of more and more cases where we're seeing cases and climate cases brought through a lens of human rights. When climate litigation is brought under the lens of human rights, it brings the opportunity to file cases under domestic laws that are established to protect and guarantee human rights. Around the world, we're seeing a greater number of cases that have been linked to claims of violation of human rights. In part, these human rights cases are increasing because governments have broadly failed to meet their commitment to protect rights in the context of the climate crisis. Many of these cases rely on constitutional or other domestic provisions that set out rights, including the right to a healthy environment. And I'd also just like to acknowledge that Indonesia has long recognized the right to a healthy environment for the Indonesian people, including in its constitution. So some examples of cases where we're seeing the human rights arguments being brought in climate litigation include in Switzerland, where in April 2024, the European Court of Human Rights ruled that Switzerland violated human rights, including the right to private and family life, by failing to take sufficient action to mitigate the impacts of climate change. In Latin America, a decision by the Inter-American Court on Human Rights in the La Aurora case found that Peru's failure to regulate polluting businesses violated the right to a healthy environment, the right to health, and other fundamental human rights. There have also been other cases brought from a human rights obligation perspective in the Netherlands, the Urgenda case, a case brought by youth in the US state of Montana, as well as cases in South Korea and Canada. And finally, just to come back to this piece around environmental law enforcement, a human rights framework is absolutely critical to ensuring that governments are accountable for their own legal obligations. And while climate litigation, including this litigation from a human rights perspective, is an incredibly important tool, it is not alone enough to advance climate justice and the protection of human rights. While courts can compel and clarify obligations and action, but governments ultimately must take responsible for upholding human rights and the rights of their people. Human rights obligations are not optional. They are legal commitments. They require states to prevent foreseeable harms and protect vulnerable communities, including communities around the world that are disproportionately vulnerable to the impacts of the climate crisis. This means enacting ambitious environmental and climate policies, phasing out fossil fuels, protecting environments, and ensuring that the people who are impacted have access to justice and remedy.
5, 6, 7, 8, 9,
For
10.
climate action to be meaningful, it must not only ensure environmental protections, but also advance human rights protections, including those for frontline communities around the world. Progress on climate change cannot and will not succeed without protecting human rights. Thank you.
Alô, som? Alô, som? Nada?
Thank you very much, Ms.
Hello,
Crispa,
sir.
for bringing
Hello,
forward
sir.
the human
Nada
rights
ainda?
dimension
Nada?
of climate change.
Alô, som? Alô, som? Alô, som? Alô, som?
Test.
Alô, som?
Check.
Alô, som? Alô, som? Alô, som? Alô, som?
Check. Oh, yeah.
Alô, som?
She mentioned
sir.
that a human rights-based approach is being used in the world, Netherlands, South Korea, and everyone else, and as well as it can be also used in Indonesia cases. And this element must always remain at the center of our work, because we are not living alone, but we're also living for the next generations, I guess. And before we move on to the question and answer discussion, I would like to have a follow-up question to the panelists. Like, first of all, to Pak Rizal, Mr. Rizal, what is the most persistent challenge Indonesia faces in enforcing environmental laws, especially in sectors that heavily influence emission, like deforestation or industrial pollutions? And for Justice Haryadi, what are the most complex issues judges faces in environmental cases? Like you mentioned before, that judges have to understand how the scientific evidence, the procedural barriers, and how it translated to be legal evidence in the court. And to Ms. Krista, if you imagine climate justice in 10 years from now, what role will human rights have played in shaping it? Pak Rizal mau jawab pertama atau Krista? Oh, Bapak.
Okay, the most persistent challenge the challenge, the present challenge in law enforcement. Okay. Maybe the present challenge is the commitment of all stakeholders. The commitment of all stakeholders. As we know that in Indonesia we have many industries built in Indonesia, and in the industry is a lot of ministry in there.
Alô, som, teste. Alô, som.
Related ministry in
Hello, sir.
in
Hello, sir.
industry. So I think the most persistent is the commitment of the all stakeholders, and people awareness. So the people awareness is also the most persistent factors. Persistent factors. Mungkin. And the challenge in the most persistent for law enforcement maybe the coordination maybe in the main actors in environmental law enforcement. We have many institutions in Indonesia. The Ministry of Environmental, the National Police, and the regional, like ya environment mungkin bisa dijelaskan.
Okay. So there is problem in regional sectors that their environmental protection agency haven't really worked well as it is in the national level. So basically it needs a coordination between all institutions that is working on the legal enforcement, as well as people awareness, that is people and not only people, corporation awareness on how to protect the environment itself. Thank you, Pak Arizal. Maybe Pak Prim or Krista will go first. Oh, Pak Prim, okay.
Okay. I think because my English is not sure, I think it's better for me to answer in my bahasa, and moderator will translate in English. Permasalahan pertama berkaitan dengan saksi ahli di persidangan. Saksi ahli di antara pihak penggugat dan tergugat itu terhadap hal yang sama berbeda. Sementara kita ketahui semestinya terhadap hal yang sama itu mestinya pendapat dari ahli mestinya adalah sama juga. Oleh karenanya kita sedang memikirkan apakah memungkinkan kedua ahli itu dihadirkan bersamaan di persidangan. Setelah itu.
Okay, thank you, Justice Prim. Justice Prim said that the challenge that is faced in the court is because the plaintiff and the defendants usually have a different expert, and they are arguing in the court, and judges oftenly become cannot understand well of their scientific debate, so their debate, that scientific debate, needs to be translated into legal arguments first. Then they need capacity to understand the scientific aspects better. And for Krista, maybe you can have a concise answer for a decision as the committee have assigned.
Yeah, thank you. You know, my envision of what climate justice looks like in 10 years from a human rights perspective, I think I'll touch on two things. First is around the people who protect the environment, the environmental human rights defenders. I think in 10 years, I would like to see a world where all environmental human rights defenders are able to safely and securely defend the environment, that there is no longer broadly killings, criminalization, harassment, and intimidation of land and environmental defenders. And I think the new provisions under anti-SLAPP are a really positive step forward, and I look forward to seeing those fully implemented. It's a really good step forward. I think the second piece is around the push for transition minerals, where we're seeing around the world we need minerals to really power the energy transition. And so I would like to see this energy push come fully in respect of the rights of frontline communities that are living near mines and processing facilities, including access to basic information about the environment, including air and water quality, a seat at the table, able to participate in consultations, understanding what projects will be before they come, and for Indigenous peoples to fully be able to exercise their rights to self-determination and free, prior, and informed consent.
Thank you, Krista. So, Excellencies, colleagues, and friends, as the time is up, we have to close this dialogues. But closing statement for this forum is today's conversation has shown that achieving climate justice requires strong commitments, institutions, firms enforcement, empowered courts, and the protection of human rights, especially the human rights defender. And Indonesia's experience illustrates that environmental enforcement is not only about compliance, it is about safeguarding communities, strengthening resilience, and ensuring fairness in the global fight against the climate change. And we move forward from the COP30, let us deepen collaboration, share knowledge, and uphold the principle of justice in every climate action we pursue. Terima kasih. Thank you for your attention, and we hope you enjoy the rest of your programs at the Indonesian Pavilion.